What are trial penalties and are they a real thing in federal court? Trial penalties are higher guidelines and, generally speaking, a higher sentence that the judge would impose if you were to proceed to trial instead of taking the plea. Trial penalties in a lot of districts are a real thing. From the jump, if you don't plead, if you go to trial, and if you are convicted, assuming the crimes of conviction would have been the same as your plea crimes of conviction, you lose either 2 points or 3 points because you do not get these acceptance of responsibility points taken off. Some judges do tell you ahead of time, you can go to trial and I'm not going to punish you for it, meaning I will give you that reduction, that 2-point reduction or that 3-point reduction in your guidelines, but you have to know if your judge would generally do that as a matter or not. And most judges don't factor in, well, the result is the same that you've taken the plea versus if you've gone to trial. And most judges do not give you those 2 or 3 points off. And you have to think about the resources that the court spends presiding over the trial. The judge looks at the evidence, the judge hears from the victims. The victims are real people. And a lot of the times the judges feel stronger about the case that trial punishment has to be more severe than plea punishment simply because they've seen these people come in and testified. So trial penalties are real. You may be looking at a higher sentence both because of the guidelines and because the judge is just more outraged by the conduct or by the nature of the offense. So it's very possible that you end up with a higher sentence if you were to go to trial, but you should talk to your attorney about what they think about your judge, what the practice is in your district, and how much above guidelines or above your plea guidelines they anticipate that your judge would go.